In this video, we'll be covering chapters 1, 2, 4, 5, and part of 6 for our Business 245 midterm review. First off, what is law? Law can be defined as that which is laid down, ordained, or established, a rule or method according to which phenomena or actions coexist or follow each other, that which must be obeyed and followed by citizens, subject to sanctions or legal consequences. Sources of law: custom, actions of representatives of people, decisions of the courts, precedent, or actions of administrative agencies, agreements between people. Next, we'll be looking at the court system in Canada, and specifically in BC. First of all, we have the Provincial Court of BC. This is an evidentiary court with usually only one judge and no jury. There's two limiting factors, the first being that you have to register in the area that the offense occurred, and the second being that you're limited monetarily because you can only receive a maximum of $25,000 in damages. Next, we have the BC Supreme Court, similar except without the two limiting factors. Following that, we have the BC Court of Appeals, which is an appellate court where you review the decisions of previous courts. And lastly, we have the Supreme Court of Canada. This is a court that has 9 judges that reviews the decisions of previous courts if it has national importance. Next, we have the Tax Court of Canada. Following that, we have the Federal Court Trial Division. This court deals with anything from patents to copyrights or any ocean or military issues. Following that, we have the Federal Court of Appeal. This is an appellate court that reviews the decisions of previous courts in the Federal Division. The role of the courts: be arbiters of the Constitution, interpret legislation, protect our civil liberties, enforce public policy, be arbiters of disputes between private parties. The litigation process. First of all, you have the demand letter. This is a formal letter explaining the situation and asking for money or giving the alternative of going to court. Secondly, you have negotiation. This is when the defendant replies, sometimes with the possibility of a settlement. Third, writ of summons, a document that establishes the plaintiff and defendant and what location they'll register in. Fourth, statement of claim, an explanation of the issue. Both of these are served to the defendant. If either of these are ignored, the plaintiff could take default judgment and win. Fifth, you have the appearance, documents establishing that the defendant will appear. Sixth, statement of defense. This is an explanation from the defendant's side. Seventh, you have the reply. All these factors are part of the pleadings process that usually takes approximately 3 months. Number 8. Demand for discovery of documents. All relevant documents must be disclosed at this time. Number 9. Interrogatories. Written questions asked by both parties. Number 10. Examination for discovery. Questions that are asked in a law office and recorded to be used as evidence later in court. Number 11. Set trial date. Note that the settlements often happen right before trial. Next, we have number 12, which is the trial itself. This is when all the factors and events that normally occur during a trial take place. Following that, we have number 13, which is the appeal process. Next, we'll be looking at tort law. Tort can be defined as a wrong to another person. Next, we'll define liability. It is the requirement to pay damages. The first liability is fault. For example, when the janitor was at fault for not posting a wet floor sign that caused an injury. Second, we have strict liability. We can look at one of our examples from the textbook for this one. There's a man named Rylands who had a reservoir. Next to his reservoir lived a man named Fletcher, and on his property, he had a mine. Rylands' reservoir started leaking water into Fletcher's mine, thus ruining the mine and creating a danger, making him liable. Third, we have vicarious liability. This is when an employer is responsible for actions of their employees. Now, we'll look at the negligence formula. For someone to be found liable, the following factors need to be present. there needs to be a duty of care owed, breach of standard of care, causation, and remoteness. And if you have all those, then you have a liability. But you need to keep in mind that there may be contributory negligence involved. The first one that we'll look at is duty of care. The famous case for this is Donahue versus Stevenson. In this case, Mrs. Donahue was enjoying a nice ginger beer when she found a snail at the bottom of her beer. She thought Mr. Stevenson, the manufacturer, was liable because he owed her a duty of care. Lord Atkin's definition is that you must take responsible care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbor. Next, we'll look at breach of standard of care. Does the conduct fall below what the standard of the position is? An example that we looked at in class is how a truck driver named Chauncey was below the normal standard because he wandered to the side of the road. Next, causation. The act of causing something that makes you liable. Now we'll look at remoteness. Whatever occurred must be reasonably foreseeable. In the Long Island Railway case, there was a man who was trying to catch up to a moving train. 2 employees successfully helped him onto the train, but while doing so, one of the man's packages carrying fireworks fell underneath the train. The train just happened to set these fireworks off. There was a woman standing down the tracks who was injured by the explosion after shockwaves knocked over a scale. Next, we have contributory negligence. This is when there's a failure of an injured plaintiff to act prudently. The most common example of this is when the injured plaintiff isn't wearing their seatbelt. Other torts. First one being deceit or fraudulent misrepresentation. This is when there's action used to deceive another. Next, we have assault and battery. Assault is the threat of the violence, whereas battery is the actual intentional harmful contact with the body of another. So we have nervous shock, when intentional or reckless conduct causes emotional distress. False imprisonment, intentionally restraining the movement of another without lawful justification. Malicious prosecution, having someone prosecuted without cause and with malicious intent. Defamation, lowering a person's reputation in the eyes of right-thinking members of society. Now we'll look at professional liability. First one is contractual liability. This is when there's a breach of contract. Second, fiduciary duty. This is when a special relationship of trust is broken. Third, the tort of negligent misrepresentation. Now we'll look at an example called the Hedley-Byrne principle. In this example, there's one company named EasyPower, and there's another firm called Hedley-Byrne. Hedley-Byrne wanted to know if it was a good idea they should loan credit to EasyPower. They asked their bank if EasyPower was financially stable, but Bank A didn't know. So they went to EasyPower's bank, who said yes, it'd be no problem to extend credit to EasyPower. However, after they gave this advice, EasyPower went bankrupt. And now, did Bank B owe Hedley-Byrne a duty of care? The Supreme Court of Canada said that there wasn't any negligent misrepresentation because there must be a known class of people within the closeness for there to be duty of care. And within the tort of negligent misrepresentation, you have the duty of care like we talked about, omissions, standard of care required of professionals, and causation or reliance. Alternative Dispute Resolution, or ADR. Any process used to resolve a dispute outside of litigation. It's hard to say, but we can weigh the advantages and disadvantages to see which one we prefer. Some of the advantages are that there's usually lower cost, reduced time to resolution, preservation of confidentiality, greater control over process and outcomes, business advantages, and specialized expertise and opportunities for conciliation. Some of the disadvantages are possible inequality of bargaining power, lack of enforcement of documents and information disclosure, possible lack of finality, enforcement challenges, and less safeguards on the process. Types of ADR: negotiation, confidential listening, mediation, neutral evaluation, mini-trials, arbitration, ARB-Med, and Medaloa, mediation and last offer arbitration. Formation of a contract, offer and acceptance. There are 6 general rules for offer and acceptance. The first one is that a contract doesn't exist until an offer is made by one person and accepted by another. Second, an invitation to do business isn't an offer. Third, an offer must be communicated. Fourth, an offer does lapse and can lapse in 3 ways. First, if a specified time period has expired, a reasonable time has expired, or either the offerer or offeree dies or becomes insane. The 5th rule is any offer may be revoked at any time prior to acceptance. And the 6th, a contract becomes binding the moment an offer is accepted. Finally, we have a unilateral contract. When the offer indicates performance initiates the contract instead of acceptance, like the Carbolic smoke ad.